Members of the jury, I'm the substitute teacher today. I'm replacing the prosecuting attorney to give the rebuttal arguments in the case of the state of Florida versus Trayvon Martin. Before I explain to you how this all happened, the prosecution would like to offer you an apology, and I'm supposed to communicate that apology to you now, and that they are sorry for the following. They are sorry that they didn't start with a story created from the truth as demonstrated by the evidence, from the perspective of Trayvon Martin. They are sorry that they didn't respect the strengths of this jury as it relates to the legal process. And then number three, they are sorry that they didn't communicate to you what we were thinking the jury's responsibilities were, or a method to help you assume those responsibilities. And it is our goal at this point in the prosecution's case to correct the errors of before. Next. So why am I here and who am I? I'm here mostly because I spend a lot of time telling stories. And we want to make sure that before this case is over that you get the opportunity to hear the prosecution's story on behalf of Trayvon Martin, who isn't here to tell his story himself. Finally, we'll talk about why you should choose the state of Florida's version of the story over the story that's been offered by the defense team of George Zimmerman and through his statements and interviews previously. Next. So why am I here? Because Trayvon Martin was a black teen, and I'm a black man with a black voice. And I don't know if you've noticed, but there isn't a black male voice or a black voice in these proceedings. Not one of the lawyers that have spoken to you, not one of you, nor the judge. The question becomes, is that important? And if so, why? I'm here because if Trayvon Martin had not been killed and only injured, his voice would be here to tell a story from his perspective. My goal is to consider his story, as well as the story of George Zimmerman, by studying their intent, which includes the emotions that were present in the moment when the story was being developed. I like labeling. I like people defining who they are. So as I tell you my name, Dr. Ed Warner Jr., what I really want you to know about me is my brand or my label. I am black, I am an educator, and I am an activist. Those are privileges that I've had as a result of a set of experiences, being black, being an educator, and being an activist. I view those as privileges because knowledge is valuable, and having personal experiences regarding something can be beneficial in us being credible in understanding a series of events and offering some suggestions. So labels are important, and we'll talk about more labels as we tell the story. Labels are important because sometimes if labels are inaccurate, we stereotype people wrongly. And if labels are accurate, we have a better sense of who someone is. There's a lot of truth to the saying. There's often some kernel of truth in a stereotype. But it's also true that we have to be careful when we stereotype that we don't assume that all potential members of that stereotype actually fall into that category. That's one of the things that self-labeling allows. It allows that individual to decide what categories they should be put in. The prosecution's story starts with a label for George Zimmerman. He's already offered his label, a reasonable guy, caring guy, cared about the community. We've had a lot of testimony so far in the case about who he is. But before I fully tell his story, I forgot to tell you how I ended up here. So let me jump back for just a second. When defense attorney Mark O'Meara started his closing argument, he said something really important. And the prosecution realized that that had an impact on the whole case. Go back, if you remember, when he talked about the importance of a jury. And he quoted Thomas Jefferson and John Adams about the value of the jury in terms of the democratic or the criminal justice process. Now, where the prosecution really agrees with Mark O'Meara is that the jury is really important. Where they disagree is how the jury is important. Mark O'Meara said, you as the jury should not use your common sense when deciding this case. You should not engage in any speculation that isn't demonstrated with evidence. He talked about your job was to apply the laws of Florida to this particular case and the evidence of this case. Where the prosecution disagrees vehemently is that the goal of this proceeding and of your value as jurors is not to try to become lawyers in 2 weeks. That the legal system, the lawyers and the judges have different responsibilities than the jury. It's not our intention as prosecutors, and one of the reasons the prosecution apologized to you at the beginning, for you to take a large quantity of data and a big bunch of complex laws and procedures. After this, they're going to give you a 27-page jury instruction and send y'all back in the room and say, figure this out. That's not fair to you. It's not what you're qualified to do. If you were to label yourselves, none of you would label yourself as a lawyer. And in that moment, if that's the way that this operates, we're trying to make you lawyers like the people that went and collected the evidence, that did the depositions, that have argued this case by bringing all of these different pieces of evidence, bringing all these different laws to bear, and saying, go in a room and figure it out the way we did. That's not what Thomas Jefferson and John Adams were saying. What they were saying is, when you have people that are trained in that legal experience, you need people who aren't trained in that experience to act as a check and balance on the system to make sure it works. So the prosecution says, anybody who tells you to not use your common sense, they're destroying the value that you as a jury member have when you walk into this room. Your value is tied to your experiences that you've had previously, and when you walk in here, you're supposed to bring those experiences and your common sense, and you're supposed to hold every person in this legal system accountable for bringing this together in a way that makes logical sense to you. And that's what the prosecution is apologizing for. They weren't doing that before now, which is why I, a person who's not a lawyer, am giving the rebuttal speech. Now let's get to the prosecution story, armed with this notion that maybe all this should be about is two stories offered up by both sides, offered up with the available evidence to support the story. We have their story. You just saw a video of their story. In their story, even though Mr. O'Meara told you, don't speculate, the very first thing you see in the story is Trayvon Martin punching George Zimmerman. There's no evidence that that occurred other than George Zimmerman's story. He says that's what happened. Trayvon's not here to give his version of those events. And that's going to be important when you think about what evidence is, what logic is, and how you're going to pick the story that makes the most sense to you. So, labels are important. Your role is to use your common sense And our job as prosecution and as defense is to create competing stories that best match the evidence to persuade you of guilt or innocence. Our label for Mr. Zimmerman is hard-headed bully. And he might be a reasonable guy, he might be a nice person, he might be helpful, he might care about crime staying out of his community. But on that night, he was a hard-headed bully. And the evidence is very clear on this issue. When he made a decision to say, I'm going to follow Trayvon Martin because he looks suspicious, what was his goal? Had Trayvon already committed a crime and he felt that he should be apprehended? Or was he suspicious that Trayvon was going to commit a crime? Don't know. Mr. Zimmerman's version of the story doesn't say. But you have to think about that. Because if he was going to follow him and attempt to apprehend him because he thought he was going or had already committed a crime, then his suspicion is that he's a criminal who's already committed a crime and needs to be apprehended. If he thinks that he is just suspicious, but he hasn't committed a crime, then he certainly doesn't want, Zimmerman doesn't want him arrested, he just wants him out of the neighborhood. He saw him and said, he's suspicious, I don't know him, he doesn't belong here. This case wasn't about race. Not in the ways that it's been discussed. This case was about profiling someone that you didn't think belonged in your community. Now, what evidence do we have? We have the 911 call made by Mr. Zimmerman. And in that call, he says, those effing punks always get away. Or those a-holes always get away, and those effing punks. We haven't talked about this in our story, but now's the time. In that moment, Mr. Zimmerman was criticizing the police department. Yeah, he was. The reason they always get away is because I've been calling you. I've called you over 25 times in the last year. And you are not responding fast enough to keep these criminals from doing crimes or after doing crimes getting away. Don't know which, they haven't said. Here's what we know about his emotional state in that moment. He was angry. I want you to just use some common sense for a second and think back in your lives to moments people you know and care about that are reasonable and good people, moments when they get angry. Are they still capable of producing bad decisions in moments of anger? Hold on to that thought for a moment. Prosecution story, who's already labeled Mr. Zimmerman as a hard-headed bully, thinks that when he profiled or saw Mr. Martin, his mind told him, I can handle this better than the police or instead of the police. Why? Because he was confident that he had a strategy for dealing with criminals. He had taken a bunch of police training classes, constitutional law classes, he knew the law. On top of that, he had taken mixed martial arts. We had a thorough discussion. And one of the things about attitude that we didn't think about in that conversation is this. The defense brought all these people up to testify that Mr. Zimmerman was bad at martial arts. But nobody asked the obvious question. Did he think he was bad at martial arts? It's an important question to ask. Because if he thought he was good at martial arts, it would embolden him, it would make him feel confident that he could handle the situation. In addition to that, Mr. Zimmerman had a backup plan in case he couldn't physically handle the person that he chose to follow. What was his backup plan? He had a gun. He didn't tell the police he had a gun when he chose to follow him. There's no evidence on his part that he told Trayvon Martin at any point he had a gun prior to shooting him. But that was the backup plan in case the mixed martial arts wasn't sufficient. But he had a plan. How do you choose to label Trayvon Martin? Only Mr. Zimmerman can decide or define the label suspicious. That's what he saw when he saw Trayvon Martin. You can't dispute that. But what you can dispute is how accurate that determination was. This was not a black teenage thug with a criminal record who had committed a bunch of crimes. This was a 17-year-old student athlete, football player, who was walking home with a bag of Skittles and something to drink. He was walking slow, according to Mr. Zimmerman, but we're not sure what that means in terms of criminal activity. Did Mr. Zimmerman think he was casing the joint? Don't know, he didn't testify to that. Did Mr. Zimmerman think that he had already committed a crime? And if so, why would he be walking slow if he had already committed the crime? Unclear. But our label for Mr. Martin, who isn't here to speak for himself, a 17-year-old athlete. The evidence is clear that his friend, Rachel Jontel, whether you like her, can relate to her or not, says she told her friend to run. Does that mean Trayvon Martin was scared of the stranger he described as a creepy? No. But does it mean that he likely took the advice of someone he trusted in his life who gave him the advice of running? In all likelihood, because she had considered the possibility that Trayvon couldn't take him, even if Trayvon thought he could handle it. Is it likely that he ran? Yes, Mr. Zimmerman says he ran and then he came back. So you've got these phone calls going on at the same time, and then we don't know what happened when these two calls ended. The next hard evidence we have is a 911 call and a witness who says that they went outside during the fight and said, "I'm going to call the police." And he went back in the house. So let's talk about emotions. Was Trayvon fearful when the stranger was following him, or was he angry? We don't know. Can't prove that one way or the other. Let's take both possibilities. He was afraid. Stranger following him, don't know who this person is, don't know what their intentions are. Certainly you can put yourself in that situation for a moment. As women, when it's dark out and you're walking home and a strange man would begin to follow you, what would your response be if he came up on you? Would you give him an opportunity to grab you or to take a swing at you? Or would the mace come out before that? I guess it depends on what neighborhood you live and what world you relate to. But here's what we know. In our story, we believe Trayvon listened to Rachel and he ran, whether he was afraid or whether he was angry. We also believe that that man over there, Mr. George Zimmerman, who's now 100 pounds heavier than he was that day, ran after him. You can hear the heavy breathing on the phone call. The phone call ends. He's already said he's out of the car and he's following him. We believe he ran and he caught him. Why? Because it doesn't make sense that Trayvon Martin would run and come back. Because if Trayvon Martin was angry or chose to fight, why would he run? He would just turn around and fight. So we get to the next question. Did Trayvon hit him first? A minor. It's equally possible, but it hasn't been discussed, that George Zimmerman attempted to grab him, or George Zimmerman talked to him with the same type of language. What are you doing here, MF? Or he tried to throw a punch at him. And maybe it didn't connect, or maybe it did and it just didn't leave any wounds. We don't know. There's no evidence for what happened. Mr. Zimmerman says Trayvon hit first. That makes no sense if you believe that Trayvon was afraid. It does make sense that Trayvon would hit him first if Trayvon was angry, but it doesn't make sense that Trayvon ran if he was angry. So in our story, we think he's afraid, because he's got enough street sense to know that that person following him is up to no good and potentially has a weapon. So we're in a fight now. There's a 911 call where screams are heard. There's a gentleman that comes outside, says, I'm going to call the police, who goes back in and also makes a 911 call. We know through the evidence that Trayvon was on top and ahead in the fight. We know from the evidence that the injuries, no matter what George Zimmerman thought they were not that significant. And in particular, I want to talk about the way that defense attorney Mark O'Meara in the closing brought in the slab of concrete to talk about it being a weapon. The injuries do not demonstrate that George Zimmerman's head was bashed against the ground. That's an exaggeration. You know what the injuries look like from my looking as a non-medical person, which is consistent with what the medical people said? They were fighting in the grass. And in nice subdivisions, the sidewalk is often up against the nice lawns, raised a little bit. And it looks like scabbing, scratching, that the struggling was occurring, and the head was maybe a little bit being hit, but mostly being scraped's the word I'm looking for, against the concrete. It looks like scrapes. When you go home, take a watermelon, take a piece of concrete, and drop that concrete on the watermelon, it will explode. If there was a serious bashing of his head against the concrete, he would have had a concussion, a serious concussion. He would have had skull fractures. He didn't have those things. He had minor injuries. We don't even know if he even had a headache. That's the evidence, and that's our story. But Martin's on top, and Martin's winning the fight, no matter how we got there. Here's where race does play an issue. 17-year-old boy in a fight with a man he doesn't know, who likely hasn't identified himself. Another man comes out, yells, I'm going to call the police. I have a son. We've had lengthy conversations about what he has to do as a black boy with regards to the police. Be very respectful. Do not mess with them, because they have the power to hurt you. They've hurt me on several occasions. I speak from experience. So while he was fighting, you have to make a couple decisions. Because if Trayvon Martin was just an irrational, violent criminal, he would have hit his head until he blacked out or he killed him. But if you're in a fight, and all of you should have some experience with someone who's ever been in a fight, the one thing that's true about a fight is, if you're not trying to kill each other, the fight ends. A likely end point for the fight for Trayvon would be when somebody said, I'm going to call the police. Now, more evidence that disproves their story and is going to support the story that I'm about to tell you. In the initial interview with the police, Mr. Zimmerman says the gun was in a holster hidden in his back. If Mr. Zimmerman was on the ground, and there's been a ton of testimony that he was on top of him and Martin had his legs pinning Zimmerman's, he couldn't reach the gun. He says Martin reached for the gun. Martin's right-handed. The gun was in his back waist where it would require getting it from the left side. In addition, Zimmerman adds to the story that Martin's hands were trying to cover him so he couldn't yell for help. But we'll talk about the help part in a minute. Together, none of that makes sense if anybody's been in a fight. But here's a story that does make sense. After beating him for a while, Trayvon Martin stopped because the fight had to end. Maybe Trayvon was going to get ready and run and go to the police. Maybe he was just going to let the man up and wait for the police to arrive. Don't know. But the likelihood that the moment that Trayvon stopped being the aggressor and backed off, and given the forensics evidence of the angle of the shot, there was some separation. That gave George Zimmerman the opportunity to raise up enough from being on his back to get his gun out of his holster and point it at Trayvon Martin. Nah, you ain't going nowhere, MF. But let's take this further. Zimmerman was angry when it started. Zimmerman, in this moment, is likely more angry. He didn't expect to get beat down. He thought his MMA was going to save him. He's angrier. And now, when Martin sees the gun, he's afraid. So we got this 911 tape, and it doesn't have consistent yelling for help. Here's what we think it sounds like. You ever heard about or saw in a movie, the game Russian Roulette, where somebody says, I got one in the chamber, and they spin the chamber, and they start shooting? That's what this sounds like. He's pointing the gun at Martin. There's one in the chamber. MF, you ain't getting away this time. Pop. Nothing happens except a yell. Ah! Couple seconds go by, there's no yelling. Happens again. Couple seconds goes by, happens again. Then finally a couple seconds go by and there's a gunshot. Being on the ground, on your back, with somebody covering your mouth, should not create helps that occur every 3 or 4 seconds. Having somebody point a gun and click that gun and threaten to shoot you 3 or 4 times, 3 or 4 seconds apart, would likely create the whelps of a 17-year-old child. Now I know there's a lot of evidence. Everybody's got some people they brought in here that said they know what the screams are. Medical technical experts said they can't tell what the screams are. Those are people hoping that that's their voice because they want their person to get justice. That's our story. That a 17-year-old stopped fighting. And finally, to end our story, remember this. George Zimmerman had put himself in a bad situation. If he lets Trayvon Martin get up and get away, Trayvon now has a story to go tell. Where is he going to go? Trayvon can wait for the police. Trayvon can run home to his father and tell him what just happened. But in either case, George Zimmerman's in a whole lot of trouble. If he disregarded police orders, he followed that kid, he got beat up by that kid, and then he pulled a gun on that kid. No one's thought about it. Trayvon Martin had to be shot because George Zimmerman needed to destroy the only evidence that would prevent him from creating the story that he needed to create to not get in any trouble. Self-defense. Next. Our story is so much more credible and consistent with the evidence than their story. George Zimmerman had a vested interest in making sure Trayvon Martin could never tell his story. He destroyed the evidence when he killed him. That's motive. That's reason not to believe his story is credible. George Zimmerman has motive